Marilyn Holifield, partner, Holland Knight law firm. I've been at Holland Knight since 1981, so the span of my litigation practice has been varied. Early on, I worked in antitrust, securities, products liability, and basic contract dispute. The employment laws opened up to jury trials. I became involved with employment defense work, and I represented national companies and some international companies that had business here in the United States in connection with employment disputes. And in the last 15 or so years, my practice has included, for the most part, protection of intellectual property rights through enforcement of restrictive covenants not to compete. A recent case that was just resolved, I'll talk about two cases because they involve both sides of the issue. One case grew out of a company acquiring a smaller company to build its book of business and entered into restrictive covenants with the owner of the smaller company that it purchased. And the principal owner of the smaller company signed restrictive covenants not to compete directly with the acquiring company, and not to solicit customers and not to disclose confidential customer lists and other intellectual property assets. That owner of the company that was acquired left and started his own company and started competing against the company that had acquired his earlier company. And in fact, he solicited the very same clients using the same client list that the acquiring company had purchased in this transaction. And so in that case, it was a case involving extensive hearings on our motions for a preliminary injunction. We ultimately obtained a preliminary injunction that was affirmed on appeal that enjoined the owner of the company that had been acquired from soliciting and acquiring our clients. And in connection with that, there was an order of enforcement that required that company to, in effect, give back the clients that had been wrongfully obtained. That's one side of enforcing intellectual property rights. Not long ago, we wrapped up a case where a former employee went out and started his own business. And in that case, we represented the former employee and the new business. And in that case, the company seeking an injunction wanted to rely on the Florida statutes that permit an injunction to be issued when an employee goes out, starts a new company, and competes. In that case, because the Florida statute is very specific in defining the circumstances under which an injunction can be issued, the efforts to obtain the injunction were unsuccessful. Ultimately, that case settled. When I was growing up, I thought I was going to be a pianist. I thought I was going to be a poet. I thought I was going to be a writer. And when I was graduating from college in my senior year, one of my older brothers suggested that I at least consider law school and urged me to apply to Harvard Law School. And I did. And I was accepted, and I survived my first semester, and I said, I've put in too much work to turn back now, and the rest is history. I think a litigator has to be a good communicator orally, but as well as in writing. So much of law in state or federal court depends on persuasive papers, but also persuasive oral advocacy. But one of the little known things, I believe, is that you really do need stamina. Part of the, at least from my perspective, part of the way you survive law school is to figure out ways to have the stamina to go through the heavy reading requirements, the heavy agenda that law school generates. And I think in terms of being a litigator, having that energy and stamina are things that also go into the mix. Companies recognize the importance of protecting their intellectual assets, the importance of protecting their formulas, their trade secrets, their customer lists, their goodwill. And those are assets that are perhaps even more important than brick and mortar assets, because in many instances, the trade secrets of a company, if they are obtained by a competitor, that could make or break a significant dimension of a company's business portfolio. Is it ultimately good for business? Maybe. Is it ultimately good for society at large? Maybe. I think there are pros and cons depending on which side of the ledger you are on. For the business, it eliminates the uncertainty of juries. Many businesses are nervous when a complicated case is sent to a jury to decide. Sending a case to arbitration where you may have people who are experts in the area, or at least trained professionally in the area that is being considered or that is the subject of the dispute, probably gives businesses a level of comfort that that sending a case to a jury does not. Sometimes the jury instructions are so complicated that it makes it difficult for the jury to follow. Another consideration is that arbitration proceedings are generally confidential. So in that context, the evidence, the accusations, the back and forth of the adversarial dialogue is behind the shield of confidentiality. For business, in many instances, that's a good thing. There are some situations where a public airing of the accusations and defeating those accusations is a good thing. So it's hard for me to say that in every situation arbitration is good, or in every situation arbitration is bad.